Hi, my name is Lauren Grocco, and I'm a licensed California attorney practicing employment law. Today we're going to talk about how to whistleblow. California has strong protections for those who report illegal conduct in their workplace to those with the ability to remedy that legal conduct or the government authorities, including health and safety violations, conduct to defraud the government, patient health and safety concerns in medical settings, and other conduct that violates a law or regulation, including conduct that violates wage and hour laws. Whistleblower laws protect employees from being retaliated against for whistleblowing. And some of these laws presume that adverse actions against employees who blow the whistle within a certain period of time create a presumption that those adverse actions were retaliation. But it is important for whistleblowers to take certain steps when they decide to blow the whistle. Now, before we jump in, let's start with the obvious. This isn't legal advice, nor should you ever seek legal advice from a video on the internet. And our office, like most other legal offices, does not give free legal advice. Nothing in this video creates an attorney-client relationship. This video is intended to provide information to the public, but because every situation is different, if you have a legal question or a dispute with your employer, you should contact an attorney. The law is constantly changing, and nothing on this video should be construed as a guarantee, warranty, or prediction as to how any individual's legal situation may play out in court or arbitration. If you've been wrongfully terminated and would like to schedule a consultation with Grocco Law, please call 949-506-1494. Back to a few tips on how to properly whistleblow. Document your whistleblowing. Do not make the reporting only verbally. I've seen so many great potential cases come across my desk, and they said, oh, well, I verbally told HR that I was not being paid properly, or I verbally told my manager that we weren't in compliance with a certain regulation. Oftentimes, those verbal complaints might as well not exist because the employer is going to deny any kind of whistleblowing. Documenting in writing and keeping a copy of that writing becomes critical. Second, do not take documents supporting your whistleblowing indiscriminately. Don't just grab every document you can. Only take what you need to support your whistleblowing. Third, if you are whistleblowing within your company, keep the communications between you and management, or in certain circumstances, human resources. We don't need to spread the word and make it gossip. Oftentimes this gives management time to actually resolve the problem, because let's be real, when we whistleblow, our real goal is to help the company resolve the problem. We're not looking to litigate. Litigations should be avoided at all costs. Fourth, document your own performance. Keep copies of your evaluations and other communications about your job performance. Employers often defend retaliatory actions against whistleblowers by claiming that the worker was doing subpar work. But if you can come back and prove that you had great performance reviews before you whistleblew, and that you received constantly positive feedback until you whistleblew, that'll help. Coffee break. If your employer starts treating you differently, you need to document this as well. Take notes, keep a diary. I have another video about documenting bad conduct in the workplace. That might help. If the retaliation becomes clear, such as you were removed from favorable assignments, transferred to a different department, given a negative evaluation, document it. If the conduct is verbal, write it down in a journal or a diary as soon as you are able, or where appropriate, consider sending a summary email to the person who provided you with the negative feedback and asking them to confirm that what they told you was accurate. Remember, California is a two-party consent state when it comes to recording, so no recording unless you are in an open public space, like on a crowded public street, or in front of a security camera, or if you have everybody on the recording's permission, and that permission should be clearly stated on the recording itself. If you are retaliated against after whistleblowing, meaning you are transferred, your pay is reduced, you receive a demotion or performance improvement plan, negative evaluation, or terminated, you may want to consult an experienced employment attorney like those at Grocco Law. Thank you.